On December 21, 2012, Stephen W. Carlson, the Independence Party candidate for the 2012 election for the U.S. House of Representatives for Minnesota's 4th Congressional District, filed a petition pursuant to Minnesota Statutes 204b.44 seeking declaratory and injunctive relief. Carlson asserts 3 claims in his petition. First, Carlson alleges that Minnesota Statutes 202a.16 Subdivision 2, which identifies those who can participate in and vote at a precinct caucus, violates his First Amendment rights. Second, he alleges that the Secretary of State improperly withheld from him the email addresses of registered voters in the 4th Congressional District, thus violating the Minnesota Government Data Practices Act and burdening his First Amendment rights to political association and speech. Third, he alleges that the district court's refusal to accept his election contest for filing infringed on his First Amendment rights. We begin with a discussion of the facts and allegations at issue in each of Carlson's claims. In his first claim, Carlson challenges the statutory eligibility requirements for participation in and voting at a precinct caucus. In every state general election year, Minnesota holds party caucuses in each election precinct. Minnesota Statutes 202a.14 Subdivision 1. The voting in each political party's caucus is restricted to, quote, only those persons who are in agreement with the principles of the party as stated in the party's constitution and who either voted or affiliated with the party at the last state general election, or intend to vote or affiliate with the party at the next state general election. Carlson asserts that he does not support certain DFL party principles that he believes promote gender discrimination. Given the eligibility restrictions in Subdivision 2, Carlson alleges that he is unable to associate with DFL voters at DFL precinct caucuses, cannot speak against the DFL party principles at those caucuses, and cannot vote at a DFL precinct caucus. Because the statute prohibits such participation, Carlson alleges that the Subdivision 2 violates his First Amendment right. The Secretary of State maintains a statewide voter registration list based on information gathered from registered voters. See Minnesota Statutes 201.021, describing the computerized statewide voter registration list that constitutes the official list of every legally registered voter in the state. 201.071 requires voters when registering to provide a name, address, date of birth, residence, and identification information, and optionally a telephone number and email address. And by the way, the telephone number is not optional. A separate public information list, which includes only voters' names, addresses, year of birth, voting history, and if provided, a telephone number, is available for a fee. And that's 201.091. In mid-October 2012, Carlson bought the public information list for registered voters in his congressional district from the Secretary of State. Before the end of October, Carlson realized that the list he bought did not include email addresses that might have been provided by any of the estimated 383,000 registered voters in the district. Carlson contacted the Secretary of State's office, which confirmed that optionally disclosed voter email addresses are not part of the public information list, and therefore were not on the list sold to Carlson. On October 30th, 2012, Carlson filed a complaint in the U.S. District Court for the District of Minnesota, alleging that the Secretary of State improperly withheld voter email addresses from the public information list. On November 5th, 2012, Carlson moved the federal court for a temporary restraining order requiring the Secretary of State to disclose the voter email addresses before the general election on November 6th. In opposition to the motion, Gary Poser, Director of Elections for the Secretary of State, explained that while voters might provide an email address when registering to vote, Section 201.091 does not include those email addresses in the definition of the public information list. He further stated that the Secretary of State has not sold, distributed, or disclosed voter email addresses to any candidate. The Federal District Court denied Carlson's motion, concluding that he was unlikely to succeed on the merits. In his third claim, Carlson challenges the Ramsey County District Court's refusal to accept his election contest, which he attempted to file under Minnesota Statutes Chapter 209. Carlson's contest was based on what Carlson contended were, quote, deliberate, serious, and material violations of Minnesota elections laws in the 2012 election. The district court rejected Carlson's elections contest filing because Carlson did not pay a filing fee, and his application for leave to proceed in form of paupers was denied. On December 21, 2012, Carlson filed with this court his petition under Minnesota Statutes 204B.44, raising the three claims described above. On December 26th, we issued an order directing the parties to address whether laches, mootness, or failure to state a claim upon which relief can be granted barred Carlson's claims. Respondents Mark Ritchie, the DFL Party, and Representative McCollum each responded and argued that Carlson's claims are barred. Carlson disagrees and argues that he has been diligent in pursuing his claims. He therefore urges the court to order that a trial be held pursuant to Minnesota Statutes 209.12 to allow for evidence to be taken and forwarded to the United States House of Representatives for use as it deems appropriate.